Welcome to the Deep Dive. Today, we're opening up a set of source materials that looks at one of the most difficult journeys anyone could take, seeking accountability after a profound medical loss. We're going to be zeroing in on Florida, specifically, and the administrative pathway for accountability.
Right, and that involves two crucial agencies. You've got the Department of Health, the DOH.
That's for professional licenses.
Exactly. And then the Agency for Healthcare Administration, AHCA, which, focuses on the facilities themselves.
Okay, so let's set the stage.
Well, the first thing to understand is a really difficult truth. For these families, the system we're about to dissect, it's often not their first choice.
It's their only choice.
It's their only choice.
So tell us why that is. Because normally, when there's harm involved, people turn to the civil courts.
Right. And that door is often bolted shut for them, purely by economics. Before they ever think about filing a complaint with the DOH, most of these grieving families have already called multiple attorneys.
And the answer is no.
The answer is almost universally rejection.
Why? Is it because the case is weak?
Not necessarily, no. It's because of a specific law, Florida statute, section 768.218.
Okay.
This law, it deals with damage caps, and it renders many medical negligence cases, and this is the term used, economically non-viable.
That sounds like jargon designed to hide something pretty nasty. Let's unpack that.
It is. A medical malpractice case is incredibly expensive to bring to court.
Right.
You have to hire multiple, very specialized medical experts just to review the records, provide affidavits, testify.
So we're talking huge costs.
We're talking hundreds of thousands of dollars, easily. And that's before a single witness even steps into a courtroom.
Okay, so the expert fees are astronomical.
Exactly. Now, if the state law caps the potential financial award a family can get, especially for things like pain and suffering, at a level that's lower than what you expect to spend on litigation, well, no rational attorney can take that case on contingency.
The numbers just don't add up.
They don't add up.
So the civil system, which is supposed to compensate victims and deter bad actors, is just unavailable. The whole mechanism is broken by the economics of the law itself.
Precisely. And that's why the source material frames this DOH administrative system not as some kind of supplement, but as the mandatory alternative path to accountability.
And our mission today is to analyze why this system, which is intended to protect future patients, is instead structured in a way that just about guarantees failure for a regular person trying to file a complaint.
It results in silence, despair, and, crucially, a potential failure to protect the public.
Okay, let's walk this journey then, starting right at the complaint stage. The sources call it the gap between grief and governance. The second a family tries to find some accountability, they hit these immediate technical walls.
Yeah, and you have to remember they're dealing with crushing grief. But the system expects them to be IT professionals.
And legal scholars.
And legal scholars, right. It starts with the basics, like just finding the right forms online, figuring out which agency to even complain to.
And then the digital portals.
Oh, they're deeply flawed. We're talking about basic things like file size limits or formatting rules that stop them from even uploading the complete medical records they fought so hard to get.
And that's just the tech side. The informational gap sounds way bigger.
It is. It's profound. The DOH expects families to translate this raw, traumatic thing that happened to them into these really complex medical legal concepts.
Concepts they have zero training in.
Absolutely none. And the agency provides basically no educational guidance, zero.
So wait, they have to frame concepts like standard of care, breach, causation, without knowing what those legally mean. Can you just, in plain language, what are those?
Sure. Think of it like a very specialized, very strict traffic court. The standard of care isn't about being perfect.
Okay.
It's what a reasonably prudent, experienced professional would do in that exact same situation. A breach is when they clearly step outside those accepted guidelines.
So running a red light.
Running a red light, exactly.
And causation.
That's the link. You have to prove that running the red light didn't just happen, but that it was the direct cause of the accident, of the harm.
It's not enough to just show a bad outcome.
A poor outcome alone is not enough. You have to draw that legal line connecting the action or the inaction to the death.
And on top of all that, there's this jurisdictional confusion. They don't know the difference between the DOH, which handles the doctor's license, and AHCA, which handles the hospital. They just see a broken healthcare experience.
That's exactly right. What they understand is simple. It's something went wrong and my loved one died.
That's the human truth.
That is the human truth they carry. But the DOH doesn't operate on human truth. It operates on rules.
Rules it doesn't even explain to them.
Right. They don't know that a poor outcome by itself is insufficient to establish negligence in this framework.
And this is where it gets really interesting, because this system almost seems to exploit their grief.
It does.
Because they don't have the legal language, they don't have the medical guidance. So they use the only language they have left.
Emotion.
Emotion. Source material says they use character judgments.
Yes. They'll describe providers as careless or reckless, indifferent, uncaring. They talk about their pleas being ignored, about being dismissed.
And while that emotional story is 100% valid from a human standpoint,
Of course.
it fails to move the complaint forward administratively.
Yeah.
Why? Why does that fall so flat?
Because, to be blunt, character judgments are not evidence in a formal proceeding.
Okay.
They speak to someone's intent or maybe their disposition, but not to procedure. To allege negligence, you have to pinpoint the specific act.
The moment.
The exact moment the standard of care was breached. The time the nurse didn't check the vitals, the surgical step the doctor skipped. The DOH isn't investigating if the doctor was a nice person.
They're investigating a technical violation of a statute.
Exactly.
And this lack of guidance also leads to unfocused complaints.
Yes, the lump everyone together problem.
They're frustrated, so they name everyone. The nurses, the residents, the attending physician, maybe the anesthesiologist, all in one filing.
Which is completely self-sabotaging. It just dilutes their strongest claims. Every single one of those professionals has to be evaluated individually under their own distinct standard of care.
So one complaint accusing 10 people of being generally careless just gets thrown out.
It's very likely to be dismissed because proving negligence against even one of them requires a laser focus on their specific role and their specific actions.
So let's talk about the raw material they do have, the medical records. The sources say these records can be hundreds, even thousands of pages long.
And they are technical, dense, full of jargon, written for clinicians, by clinicians.
It's a mountain of data, but without a map.
That's a perfect way to put it. And the DOH offers zero help in reading that map. Families can't tell what's routine and what's a huge red flag. They don't know the significance of a dropping lab value on page 400.
It's like being handed a complex legal document in another language and being told, find the mistake.
Yes. Exactly that. So what happens is the family just uploads hundreds of disorganized pages. And to the investigator, that just looks like noise, not evidence.
They haven't been taught how to find the signal.
And so the complaint just dies under the weight of all that unstructured information.
So once this, structurally flawed complaint is finally filed, we move into what the sources call the system of procedural insulation and silence.
This is where it gets very bleak.
After they hit submit, the family's role, it's over.
It effectively ends. They are silenced, they can't clarify anything, they can't review the investigator's summary to see if it's even accurate.
How does that compare to a civil case?
It's night and day. In the DOH process, the investigator notifies the healthcare professional, the respondent.
Right.
That professional immediately hires a lawyer. They prepare a highly structured legal rebuttal, sometimes with their own expert opinions.
And the family hears nothing while this is happening.
Nothing. In a civil court, the complainant's lawyer would get to question that rebuttal, take depositions, challenge the testimony.
That recourse is just not there at the DOH.
It's not available. The agency takes the initial unguided complaint from the family, then allows the professional to mount a legally sophisticated defense, and then decides the whole thing in private.
That sounds incredibly cynical. Is the system intentionally biased, or is this just an accident of bureaucracy that ends up shielding the professional?
The sources suggest it's more the second one, an accident bureaucracy that achieves the first. The DOH sees itself as a neutral investigator.
Not an advocate for the victim.
Correct. But since the whole system operates as if complainants are already fluent in this complex language and it gives them no tools, the structure itself almost guarantees that most complaints will fail.
They just die on the vine, regardless of the actual merit.
That's the term they use.
And for the family, months just go by in total silence. They don't know if the complaint is active, stalled, misunderstood.
Or just dismissed. It creates this deep, deep mistrust. And it's the ultimate procedural insulation. When a case is closed for lack of evidence.
Because the evidence wasn't presented correctly.
Right, because it was mixed with emotion or buried in 1,000 pages of records. Any underlying negligence, if it was real, just goes undetected, uncorrected.
So we have a huge danger here. The system that's supposed to protect the public is actually acting as a filter. It allows potentially negligent practitioners to keep practicing because the hurdles are just too high for the victim's family to clear.
The conclusion is pretty stark. If the civil courts are closed by law and the administrative agencies are structured to prevent any meaningful participation, well, accountability has effectively been engineered out of the entire system.
Okay, so what does this all mean? The sources don't just point out the problems, they offer a pretty robust set of structural reforms.
Yes, and the goal of these reforms isn't about, emotional appeals. It's about procedure. Procedure designed to find the truth, not filter it out.
And to restore some legitimacy without compromising the DOH's neutrality.
Or the professional's due process rights.
Yeah.
Exactly, and it starts at the very beginning, at intake.
So reform number 1, structured intake triage. What does that look like?
So instead of a complaint going straight to an investigator, you have a two-stage process. Trained staff, not investigators, do a preliminary review.
Like a customs screening.
That's a great analogy. Their only job is to spot missing facts, jurisdictional errors, is this a DOH or an AHCA issue, and to see if the family needs to file separate complaints for separate professionals.
So it's about separating the signal from the noise at the front door.
Before the investigative clock even starts ticking.
That makes sense. It saves time. But what about that jurisdictional problem where they filed with the DOH, but it should have been AHCA?
That's reform number 2, mandatory agency referral obligations.
Yoni.
If the DOH sees it's not their jurisdiction, they must be required by law to notify the complainant, clearly identify the right agency, and then either transfer the complaint with their consent or give them clear, simple instructions on how to refile.
So no more just closing the file silently.
Closing the file silently and saying wrong place is an abdication of their duty to protect the public.
Okay, now to address that fundamental knowledge gap, the legal language. That brings us to reform number 3, guided complaint frameworks.
Absolutely essential. The DOH needs to provide standardized, neutral, plain language guidance.
Educational, not advisory.
Exactly. They teach you the rules of the road, but they're not your lawyer. It needs to clearly explain concepts like standard of care and causation and what counts as relevant factual information versus an emotional story.
I like that. Educational transparency. Okay, what about the mountain of disorganized medical records?
That leads to reform number 4, evidentiary assistance without advocacy.
Which means?
It means offering optional, non-substantive tools. For example, checklists for common complaints, like if you think there was a medication error, make sure you have the administration time and dosage noted.
And simple text solutions for the big file uploads.
Crucially, you help the family organize the evidence coherently, but you stop short of interpreting the content for them.
And finally, breaking that structural silence. Reform number 5, complainant feedback loops.
This is critical for legitimacy. Before a complaint is closed, the DOH must provide a brief, written explanation.
Identifying the general reason for closure.
The general reason, not a detailed summary of the defense's argument, but, lack of jurisdiction or insufficient evidence to meet the standard of proof.
That stops the family from thinking their claim was just ignored.
It prevents that speculation and mistrust.
And what's key here is that none of these reforms change the burden of proof. The DOH stays neutral.
But they fundamentally change the accessibility of the system. They restore credibility to a process that right now allows real risks to go unexamined because it systematically excludes the people most affected.
It shifts the focus from, insulating the process to genuinely investigating the facts.
Yes.
So what does this all mean for you, the learner? Accountability doesn't require guaranteed punishment, but it absolutely requires a process that's capable of finding the truth when serious allegations are made. The current structure in Florida, whether by design or by accident, prioritizes procedural insulation over a genuine, public-focused investigation.
And if the legislature is going to prioritize procedure so much that it keeps the civil courts closed by statute and then also structures the agencies so that regular people can't effectively participate, well, accountability just ceases to exist. It gets replaced by structural silence.
So here's something to chew on. If administrative agencies and civil courts are both structurally designed through economics or procedure to prevent accountability, what is the ultimate cost to a society that prioritizes procedure over the truth of patient safety?